Okay, well, good morning once again, everyone, and a warm welcome to you. Thank you for joining us this morning for the Spanish Chamber of Commerce in the UK's webinar on English law in 2021, Your Key Questions Answered. This is the third time we've held an event of this nature, and it's always gone really well, so we're really delighted to be holding it again today in 2021 with a brand new panel of speakers. So of course we're going to be hearing from some different speakers from different law firms from within the British Spanish Law Association, which are members of the Chamber who are holding this session with today. I'm just going to hand over now to Álvaro Aznar-Azcarate, who is the chair of the British Spanish Law Association. He's just going to be giving some welcoming remarks and introducing the speakers that we have with us today. Over to you, Álvaro.
Thank you, Hannah. Good morning, everyone, and welcome to this third webinar that we have organized between the British Spanish Law Association and the Spanish Chamber of Commerce on navigating Anglo-Welsh law. Basically, these webinars are aimed at professionals that have relocated to England and Wales and are not familiar with the legal systems here in England. These past 2 years, we have addressed other areas of law, such as family, immigration, private clients, criminal law. And this year we have decided to give it a more commercial employment and conveyancing spin. We are delighted to have a fantastic lineup of speakers who will give you an insight to their fields. So joining us this morning, we have Julia Hutchins. Julia is a partner in the conveyancing team in Buckle Solicitors. Julia can assist on buying and selling residential property, dealing with leaseholds and freeholds, transfers of equity and mortgages, as well as equity releases. Julia is very busy with the stamp duty holiday that is ending in a couple of days. So she will be leaving us shortly after her presentation, but you can send her any questions by email and she will be happy to respond to your queries. Also joining us, we have Stephen Oliver, also a partner at Buckle Solicitors. Stephen has a broad experience in company and commercial law, assisting clients in managing their legal affairs from the inception of a business to the eventual sale. Stephen has acted on numerous private company acquisitions, including the private education sector, negotiating contracts, and helping clients minimize acquisition risk through the due diligence process. Also, we have today Gemma Ospedale, a partner in the London employment team at Royds Withy King, where she has been there for 20 years. Gemma specializes in advising employers on restructures and complex senior management issues involving dismissals, discrimination, and tactical exit strategies. Gemma also advises on 2P transfers in commercial transactions, and her practice covers all areas of employment law. And last but not least, we have also Victoria Gonzalez, who is a notary public in John Benn & Sons. Victoria became an English solicitor in 2005, obtained the Cambridge University Postgraduate Diploma in Notarial Practice in 2007, and was admitted as a notary public in 2008. Victoria specializes in Spanish matters with a particular focus on international and inheritance and company law. We will have time for questions and answers at the end of all presentations. And as I mentioned earlier, Julia will have to leave us shortly after her presentation, but you can address any questions to her by email. So over to Julia, please.
Thank you very much. Good morning, everybody. I am a partner at Buckles. I've been there just over a year. They acquired my firm in lockdown, which was fascinating. So that was good fun. And yes, at the moment, the stamp duty holiday, which is a tax paid in England and Wales, ends at the end of June. So everyone's trying to get in before then. My purpose of today is to guide you through how to buy a property in England and Wales. It's a slightly different system. So any queries you have, obviously let me know. But I have a presentation for you. So I will share my screen now. Not what I wanted. Just bear with me. Right, purchasing a property in the UK. So the purpose of today is to provide you with a process of how you do that, some top tips for you when considering buying a property, how you can own the property between you, and some general terms about what things mean, searches that you carry out when you buy a property. So buying a property in the UK is called conveyancing, and the timescale to do that between putting your offer in at the estate agent to completion is about 6 to 12 weeks. There's lots to do in that time, and the costs of which can range anywhere between about £660 to £4,000, including VAT, and that's up to properties of about £1 million. And those fees are the solicitor's fees for acting for you in purchasing the property. There's additional costs, which we'll come to later, that's on top of that, but that's generally what you would pay a solicitor for to act for you in acquiring the property. The purpose of my job really is to make sure that people can buy a good and marketable property, that they're informed and they know what it's about. So that's really what you pay the solicitor's fees for. So what I do is you put an offer in on a property and then instruct a solicitor. They'll carry out ID checks for you. But your job would be, if you wanted to finance the property, you'd have to make sure you get a mortgage agreed in principle. And obviously carry out searches. That's always a term that people wonder what searches mean. And searches are carried out at the local authority, water and drainage search and environmental search. And they're all done to check that what you're buying is good and marketable. And we'll come on to searches a bit more later. It would be your job to carry out a survey. So make sure that you instruct a good surveyor. Again, at Buckles, we can recommend surveyors, or an estate agent can do so. And their job is to check the fabric of the building. So my job is to make sure you can legally buy it. And a surveyor's job is to make sure that it's not falling down. So when I'm instructed, I get from the seller solicitors a contract package, and that consists of 2 copies of the contract, a fixtures and fittings form, which is the one that most people are most interested in. Are those fitted wardrobes included, and the summer house at the bottom of the garden? And a property information form, which is completed by the seller, which provides quite a lot of information about the property. Things like boundaries, have they had any disputes with their neighbours? Is it connected to mains drainage? Are there any occupiers in the property? Once I get all that information, that's when I put in hand the searches, and that's when inquiries are raised on the paperwork I already have. So the title to the property is registered at the land registry, and I get a copy of that. And the first thing I do is check that the seller can actually sell it. Sounds like a daft question, but Mr. Smith owns the property and Mr. Smith has died. I need to see a copy of that grant of probate to check that his executors can sell it, or it might be sold by one party and actually the registered owners are 2. So the next job then is to receive those inquiries back and to receive those searches back. Once all the information is collated, I would then do a property report to my client explaining exactly what's on the title, exactly what's in the information, exactly what's in the searches, so that they can make an informed decision about what they're buying. And this is just another slide to explain that once everything is then signed and everybody's happy, a deposit is then paid, and that's usually a 10% deposit, and that's payable in exchange, and it's handed over to the seller's solicitors on exchange. It's always the topic that everyone asks me, what does exchange, what do we actually do at exchange as solicitors? And what we actually do is there's a formula of words that are used that bind the contract. And that means that everybody is then legally bound, which means that to come out of that contract would incur financial penalties. So when we exchange contracts, we set a completion date, and the completion date is the date on which it completes and you can move in and you can collect the keys from the estate agent. So after completion, I register you at the Land Registry, which is the English system by which all properties are registered and have their own title number. And I also submit the stamp duty form, which is a tax payable to the government for purchasing a property. At the moment, the holiday is that you don't pay any stamp duty up to 500,000, but come the end of June till the end of September, that threshold goes to 250,000, and anything over and above that, stamp duty is payable. If you purchase a property abroad and you live abroad and purchase a property in the UK, you pay a 2% surcharge. So whatever the level of stamp duty is at that time, you would then pay 2% on top of that. So my top tips for buying a property: avoid long chains. New builds usually have a strict time limit to get to the point of exchange of about 28 days. Engage a proactive solicitor like myself. And make sure you can talk to your solicitor as well. It's really important to have a good relationship with them and ask as many questions as you want, because this is usually a big financial transaction. So make sure you get people on board that you can trust. And also that goes for a mortgage broker too. And make sure that they're in regular contact with you. I always make a point of contacting my clients at least every week, even if it's a case of waiting for stuff to come back. At least people know what I'm waiting for. Make sure you get all your ID documents in order. Make sure that they're usually photographic ID and address ID. This enables me to carry out my my due diligence checks on people quickly. And make sure you get a mortgage in place in principle too. This is a big section that people ask me about, how you own a property in the UK. So whoever wants to own a property has to be on the title deeds, and whoever is on the mortgage should also be on the title deeds. So if there's two of you, there's two different ways you can own it. There's joint tenants or tenants in common. And joint tenants means that, again, you're both registered on the deeds, but if one of you passes away, the property automatically passes to the other. If you own the property as tenants in common, you're again both registered on the title deeds, but you each have a severable share. And what that means is you can own it as different percentages. So you can still own it 50-50, but 70-30, 60-40. And the reason for this is that one person might put in more money than the other. So one person might put the deposit money in and decide that they want a greater share of the property. Or a party has children from a previous relationship and therefore wants to protect their share and leave their share in their will to somebody else other than the other registered owner. In these circumstances, we would always recommend that you have a declaration of trust, which is a document that notes what percentage shares you both have. It can be as simple or as complicated as you like, but it accounts for who pays the mortgage, who pays the bills, what happens in the circumstances if you were to split up, can you buy the other party out? So it's a really useful document. And again, at Buckles, we do that. Coming back slightly to the point on searches, there are basically 4 searches that we do. A local authority search is really important because it will show if the road outside is adopted, any planning permissions, building regs to do with the conversion of the property, check that there's no notices from the local authority that works were carried out and they shouldn't have been. An environmental search is also really important to make sure the property is built on land that's not contaminated. I acted on somebody buying a property, a new build, on a site that was originally a garage, and actually there was an oil tanker still buried under the ground, and each property there, not my client because we discovered it beforehand, had to pay £60,000 to remediate the land. So it's a really important search. Water search checks if it's connected to mains drainage and mains sewerage, and a chancel search. It's a search to make sure that you don't have to pay towards the upkeep of the chancel within a church that's near the property. And land registry searches are searches to protect the title so that you can purchase the property without somebody else doing something to the title, i.e. taking a mortgage out against it. So there's just some terms for you, just to sum up really. So basically in this country, it's for a buyer to be aware of what they're purchasing. It's the solicitor's job to make sure that we investigate the title, to make sure it's good and marketable and you can purchase the property. Exchange is when you're legally bound, and completion is when you move in. So I will leave it there. Just to say that I'm, as I've said before, I'm a partner and head of conveyancing in the Cambridge office for Buckles. Please email me with any queries that you have. We're always here to help. I think it's really important that people make an informed decision about what they're purchasing. So yeah, just email me if you have any questions. And that's me, and I'll hand back to Alvo, and thank you very much for listening. I'm sorry I have to rush off, but yeah, feel free to contact me.
Fantastic, Julia, thank you so much. And now, Stephen, please, if you can give us the hindsight and your insight, sorry, to company and commercial law.
Good morning, everybody, and thank you for attending this webinar. I'm going to deal with basic company law, and in particular the creation of a limited company here in the UK. Over the last few years, and in particular since Brexit, we've seen an increasing number of foreign companies, particularly those from the EU, who previously traded with the UK through their own entities in those countries, need to set up a UK limited company for the purposes of trading with the UK and getting around certain tax complications that there are and customs complications. So my talk is going to be a very basic guide, and we'll deal with the types of limited company or types of company available, the steps you need to take to form one. I'll deal very briefly with articles of association, that's the company's constitution, and give you some practical tips towards the end. I just share my presentation with you. Okay, so dealing firstly with the different types of companies, we've got private companies, and there are essentially three types of private companies. There's the company limited by shares, which is the type of company I will deal with primarily. There's the company limited by guarantee, which is a company that's generally used for charities and non-trading companies. There are unlimited companies, which I won't go into, but they're often used for things like clubs and associations. We've also got public companies. Again, these are large companies that can be traded on the stock exchange, and that's not an area I'm going to deal with. And you also see on the list limited liability partnerships. Now, you might think it a bit odd that I've included partnerships on a list of companies, but technically, under UK law, a limited liability partnership is a body corporate, and many of the rules that apply to limited companies apply equally to limited liability partnerships. So just to give you some very basics as to what a company is, and I suspect most people know, but the whole idea of a company is that it's a separate legal person to the people who actually own it, the members. Those individuals, members, don't have any liability to third parties, generally speaking, and the amount of their liability is limited on liquidation of the company. In respect of a company that's limited by shares, that liability on a winding up is limited to the amount of any unpaid share capital, So shares can be either paid or unpaid. So you might have a £1 share on which someone pays 10 pence. And if the company is wound up, then the member's liability on a winding up will be 90 pence. So that's the difference between the amount they paid when they got the share on incorporation and the amount that was unpaid, but that's the limit of their liability. In respect of companies limited by guarantee, the company's constitution will say what the amount of the guarantee is, and in many cases it's £1. So that's essentially what a limited company is. What are the basic requirements for a company limited by shares? Well, it needs to have at least one member, and that person can be a natural person or a legal person, such as another company or an LLP. It has to have at least one director. And again, a director can be a natural person, or it can also be a limited company, but the company must have at least one natural person as a director. For small private companies, there's no need for a company secretary. I think the big point to note in the United Kingdom is that in terms of share capital, there is no minimum amount of share capital for a private company. So a private company could have a share capital of, for example, £1 or even less. The shares themselves could be in penny denominations. So it's quite straightforward. You don't have to invest a lot of money in the company to set it up. I think, as I've explained previously, you don't need to pay any amount on the shares when you set it up. So you could say the company has a share capital of £1, and that £1 need not necessarily be paid into the company's bank account when it's set up. But as I said, if the company is liquidated, then the members would have to pay the full amount of that pound on liquidation at some point in time. The company will need articles of association, so that's the company's constitution, and I'll deal with that a little bit later on in these slides. It's very important to decide whether the company name you want to use here in the UK is available. So what you can do is check the Companies House register online to find out if your chosen company name is available. And even if it is, then you've also got to check the trademarks registry, just in case the name that you've chosen as a company name might possibly infringe another company's trademark, another person's trademark in the UK. Again, these are checks that are easily done online, and you'll see at the end of the presentation that I've provided you with a few links to go directly there. So what information will you require to set up a company, or what information does the lawyer or accountant or company formation agent need to enable you to set up the company for you? So we'll need the members first. Well, the first members are known as the initial subscribers of the company. We'll need the information about the subscribers, so namely their address, name, full name. If it's a company, a limited company, we'll need to know where that company is registered and its company registration number. Like most other companies in the EU, the UK enacted legislation requiring companies to give details of the people who are actually in control of the company. And these people are known as persons of significant control, or if that person is a company, a relevant legal entity. So those are usually people who have more than 25% of the shares in the company, and those people's details have to be provided. we'll need the director's details, so name, address, date of birth. And you don't have to give, the director's personal address doesn't have to be provided for publication on Companies House, but you have to give it to Companies House so they've got it. But you can also provide what's known as an address for service, so where any legal documents are sent for the director, and that's usually the company's registered office. Each company has to have a registered office. That's a place where formal documentation is sent to the company. So documentation from Companies House, legal proceedings if you unfortunately get involved in those. And that the registered office can be anywhere here in the England or Wales if the company's incorporated in England and Wales, and Scotland if it's in Scotland. But it's generally held by accountants and lawyers. The other information that you'll need to have is the type of business that the company is going to conduct, because each company has what's known as an SIC code, and which is a classification of different types of businesses, and that needs to be provided on incorporation. As I said earlier, each company needs to have a constitution, which is known here in the UK as Articles of Association. What the Articles of Association do are basically set out the rules between the members and the company. So how members' meetings take place, how directors' meetings take place, how shares are transferred, whether shares can be transferred to anyone other than a member of a company. So it's basically the regulations between each of the members and the directors. Now, these articles of association can be model articles, which the government publishes, and these are known as default articles. So if you don't have your own articles of association, you'll be deemed to have the model articles, which are very basic. And they tend to be suitable for small companies with just 1 or 2 shareholders. But if you're going to have a number of shareholders, then I think it's a good idea to have bespoke or tailored articles of association, particularly to deal with things like transfer of shares, what happens if one of the shareholders dies, whether shares, who can buy the shares at what price. These are all things that would be dealt with in what we call bespoke or tailored articles of association. You'll see there also that I've mentioned shareholders' agreements. Now, a shareholders' agreement is a private document. The Articles of Association is a public document and is published on Companies House website. So if there are arrangements between the shareholders that you wish to keep private, those are best dealt with in a separate shareholders' agreement. And the good thing about a shareholders' agreement is that it can cover all manner of issues between the parties. So it can cover things like the amount of dividends that would be paid, who can elect directors. So it can be as complex as you require it. And it's definitely something that I would recommend if there are more than two shareholders. So how do you go about setting up a company? Well, if you've got all the information that I've mentioned previously, most people go to either a company formation agent or a lawyer or accountant to set up the company. Here in the UK, it's a very swift process, actually. Once all the information is available and you've paid the relevant fees of the lawyer or accountant, the process can actually be done the same day. And what's known as the certificate of incorporation, so proof that the company exists, will be available online. Alternatively, you can purchase a ready-made company off the shelf. These are created by company formation agents. but that process will require the transfer of the initial subscriber shares, which will be held by company formation agent. It'll require appointment of new directors, a number of filings at Companies House, change of the registered office, and often it's much easier simply to provide all the information that you need to give it to the company formation agent and get them to set up the company as you want it to be. So after incorporation, things that you might want to think about in terms of corporation tax, the company will be automatically registered for corporation tax via the incorporation process. You'll receive what's known as a unique tax reference number, and that'll be sent through to the registered office of the company. If you're going to employ people in the UK, and if you're going to trade in the UK and be subject to VAT, then you'll have to apply to register for VAT and PAYE, which is pay as you earn. Each company will get what's known as a unique filing code. So this code enables you to go online and file changes for the company, such as the changes of any directors, changes of registered office, accounting reference, any new shares that you issue. And the final point I mentioned here, and I think it's a point that many people overlook, especially if you're coming from overseas or you remain overseas and want to have a UK company, is that in terms of a bank account, it has become increasingly difficult for companies in the UK without a resident UK director to open a bank account. Many of the high street banks don't permit it. And most people are now heading to the startup banks like Starling and Revolut if they don't have a UK resident director. So that's something I think you need to think very carefully about before, if you are remaining abroad and you don't have a UK resident director, how you sort out your banking arrangements before you actually set up the company. So in summary, Paris and many other jurisdictions, setting up a company in the UK is very straightforward. There's no need for any notarial intervention. There's no need to pay big monies on account in terms of share capital. And as I said, but the very important point is to explore your banking arrangements well in advance. Finally, I've just given you some useful links if you want to look into the situation yourself. There's a link to Companies House registration and filing, so starting a company. There's also a link to a trademark search if you want to check that the name that you want to choose is available. I've also put in there something for those of you who want to have a UK branch. I didn't go into that, but there's a guidance of what you need to do if you want to register a branch of a foreign company here in the UK, and a link to how to register for VAT. So thank you very much for listening. If there's anything I can do to help you with any of your business needs here in the UK, I'll be very happy to do so, and I'll take questions at the end of the session. Back to you, Alvaro.
Thank you very much, Stephen. Gemma, over to you.
Thank you very much, Alvaro. My talk leads on quite nicely from Stephen's, actually, because once you've set up your company, the next thing you may want to be thinking about is taking on employees. And I'm just going to give you a sort of an overview of the basic tenets of English and Welsh employment law, to give you an idea of the kind of things you're going to be facing when you decide to take on employees. And the relationship between the employer and the employee is essentially governed by two factors. You've got the contractual relationship on the one hand and the statute or legislation on the other. And the important thing to be aware of is that it doesn't matter whether you're a multinational PLC or whether you just want to employ 1 or 2 people, or even a domestic nanny, because I've had issues on that line along before now, the employment law will apply to anyone who takes on employees and also workers. Now, the contractual relationship is defined within the contract of employment or written statement of terms and conditions, which is mandatory to supply from day 1 of the employee's employment. And this will contain terms like pay, hours, holiday, notice periods, and they can range from a very simple document to something quite complex in the case of senior directors and managers. Statutory rights are primarily contained within the Employment Rights Act 1996 and the Equality Act, which came into force in 2010, along with a very large number of regulations, many of which have indeed been derived from the European Union when we were members. The Employment Rights Act governs matters such as the right of employees not to be unfairly dismissed, redundancy rights, working hours and rest breaks, holidays, whistleblowing, and many other employee rights. The Equality Act is concerned with the right not to be discriminated against, and it contains what are known as protected characteristics, so that if an employee or a worker is treated less favourably because of these characteristics, it can give rise to a claim for discrimination. Moving on to contractual rights, if either the employer or the employee breach the terms of the contract, either could potentially have a claim for breach of contract. It's more usual for this to be the employee if the employer has committed a fundamental breach of contract so that the employee feels they can no longer continue to work there and they have no choice but to resign. And if that happens, all the terms of the employment contract fall away, including, which is quite significant for employers, any post-termination restrictive covenants which they may have in their contracts, which prevents the employee from going to a competitor or clients, they all fall away. If the employee leaves without giving the required notice, the employer may well have an action for breach of contract, but will only really be able to bring that claim as an action in damages if they suffered actual financial loss. So where you might find it happening is if a very senior employee who generates a lot of revenue for the company leaves without giving notice and the company loses that revenue as a result, they may have an action in damages for breach of contract. Notice periods are contained within the contract of employment, and you usually have the same notice period for employers and employees, although they can be different. There is also a statutory minimum notice period, which is to be given by the employer, which is 1 week for every year of service up to a maximum of 12 weeks. So if the notice in the contract is less than the statutory minimum notice, it's the statutory notice which takes precedence. So in other words, if you've got a contract that says 1 month on either side for employer and employee, but the employee has been there for 8 years, the employer would actually have to give them 8 weeks notice, not the 1 month in the contract. Claims for breaches of contract are generally brought in the civil courts, with some limited claims brought in the employment tribunal. Moving on to look at some statutory rights, and all breaches of legislation are claims which are brought in the employment tribunals. The main one is the right not to be unfairly dismissed. The employee has to have a minimum of 2 years continuous service to bring this claim in the tribunal. So if you're an employer and you've got a member of staff who's underperforming or generally doesn't fit in and you feel they're not working out, you need to make sure that you issue them with notice of dismissal before their 2-year service period is up so that they haven't gained rights in unfair dismissal. The one caveat to that is if the employee can validly complain that they've been dismissed unfairly for a discriminatory reason, or if they've whistleblown, because they don't need 2 years service to bring a claim that they've been dismissed for one of those reasons. I had a lady client a few years ago who'd only been employed for 4 days, and she whistleblew. She was finance director, and she brought a successful employment tribunal claim because she had been dismissed because she'd whistleblown. And that was only after 4 days employment. Employees can take their claims to an employment tribunal and say they've been unfairly dismissed. And if they succeed, they may be awarded up to a maximum of the lower of 1 year's salary and £89,493. And this is subject to them not having obtained alternative employment and offset that against their actual losses. They're also entitled to what is known as a basic award, which is calculated in the same way as a statutory redundancy payment. And I'm going to come on to redundancy now. Employers have the right to make employees redundant, either if there is a reduction or cessation in the type of work that they do, or if the location where that work is undertaken changes substantially. In other words, if an office relocates from London to Manchester, there's no longer the need to do the work in London, but there is the need to do it in Manchester. But if the employee doesn't want to move with the work, they can be made redundant. They must be consulted on the proposals to remove or change their role and offered any suitable alternative employment which is available. If their redundancy is confirmed, those who have over 2 years' service at the date of their redundancy are entitled to a statutory redundancy payment, which is 1 week's pay, but it's capped at £544 per week, multiplied by the number of full years worked up to a maximum of 20, and there's an additional multiplier depending on their age. So it's not very much, basically. Some employers will offer enhanced redundancy payments, but that's up to them if they do. If employers propose to make redundant more than 20 staff at one establishment within a 3-month period, there is an additional obligation to collectively consult with the affected employees, either through trade union representatives or appointed employee representatives. And that consultation period has to be for a minimum of 1 month before the first of the redundancies takes effect, and 45 days if the number is 100 or more that are affected by the redundancy. And if these consultation obligations are breached, protective awards can be made in an employment tribunal of up to a maximum of 13 weeks actual pay per affected employee. So it can be quite a draconian punishment if the consultation obligations for collective consultation are not adhered to. Moving on to discrimination and the rights under the Equality Act, and these are a key piece of employee and worker protection. In contrast to the rights in unfair dismissal, which are limited to employees only and not workers, because they have a different definition, which is outside the scope of this talk, the right not to be discriminated against protects workers and employees who've got a protected characteristic. And those characteristics are sex, race, disability, religion or belief, age, sexual orientation, and gender. The Act also covers protection from victimisation and harassment that are connected to a protected characteristic. Claims for discrimination, victimisation, and harassment are all brought in an employment tribunal, and if they are successful, the tribunal can make an award for injury to feelings as well as any compensatory loss of salary which the individual may have suffered as a result of being discriminated against. So this is where you get quite a few of these large discrimination awards for 6 or 7 figures. That is because it's the loss of salary that the individual has suffered through being dismissed or being forced to resign as a result of discriminatory treatment. Now, there are quite a lot of family-friendly rights in England and Wales. The key ones are the maternity, paternity, and shared parental leave. The protection for pregnant women and those returning from maternity leave are particularly strong, and women have the right to return to the same job after 1 year's maternity leave, unless it's not reasonably practicable for them to do so, in which case they must be offered a role which is suitable and appropriate and commensurate with their previous level of role. Women who are placed at risk of redundancy while on maternity leave have the automatic right to be given, without going through a selection process, a suitable and appropriate alternative role, even if this means giving someone who is not on maternity leave but who is more skilled or experienced. They have to miss out on that if there is a woman on maternity leave who is also competing for that role. It's a common misconception that you can't make women on maternity leave redundant. You can, but they do have this automatic right to preference over any suitable roles going over anybody else. Women are entitled to up to a year's statutory leave, of which 39 weeks is paid at a set statutory level, which is currently about £151. Some employers will give enhanced maternity pay terms. Many opt simply to pay the statutory. Men have the right to 2 weeks statutory paternity leave, and again, they're paid at the same statutory rate as women. And there's been an important development in the last few years of a concept known as shared parental leave. This means that a woman and her partner can share up to 50 weeks of the woman's statutory maternity leave if the mother opts to return to work earlier, and her partner can take the balance of the maternity leave. The take-up on this has generally been fairly low, The reason we think is probably because where you've got a husband and wife, it is quite often the husband who is the higher earner, and it wouldn't make sense for him to relinquish higher earnings to take up the shared parental leave, the balance of the leave that his female partner has when she goes back to work, and be paid at the statutory minimum payment level, which, as I say, is about £151 a week at the moment. In contrast, of course, if it's the mother who's the main breadwinner, then it might make more sense for her partner to take the shared parental leave and the statutory pay, and for her to go back to work. There is a right to request flexible working, and in 2014, this right was extended from just people who have childcare responsibilities to any employee in the workforce, provided they've got a minimum of 26 weeks qualifying service. They have to make a written request, and the employer has 3 months to consider the request and give a decision. They can only make one flexible working request in any 12-month period, and if the employer is to refuse it, it has to be for one of the stipulated permitted grounds for refusal. And if it isn't, the employee can make a complaint to an employment tribunal. Requests will almost always involve a change to hours, whether a reduction in hours or change to the hours worked, or requests to work part of the working week flexibly. And on that note, given the pandemic and huge numbers of people have been working from home, we are inclined to think that it is going to be far more difficult now for employers to refuse a request to work part of the week from home if employees have been doing so perfectly satisfactorily for the last year plus. So that's an interesting development in flexible working requests. The working time regulations govern the amount of time people work, and they apply to employees and workers alike. Generally speaking, there is a right to work no more than a maximum of 48 hours in the working week, but this can be opted out of in the contract of employment, and the employee can opt back in again on 3 months written notice. The regulations contain provisions regarding rest breaks, daily and weekly, with a requirement for at least 20-minute break after continuously working for 6 hours and an 11-hour break between shifts. If the work the individual is carrying out doesn't allow for these breaks to take place, they must be given as soon as reasonably practicable. And there are some exceptions in the working time regulations for industries which fall into this category, such as airlines, railways, shipping, and the medical profession. The minimum period of annual leave each year is also prescribed in the working time regulations, and this is 28 days, which is the working time directive minimum of 20 days, plus the 8 public holidays which we have in the UK. The National Minimum Wage Act and regulations govern minimum hourly rates, which must be paid in respect of virtually all workers, and these increase on an annual basis. The rates are divided into 5 categories depending on age, with the highest being the national living wage, which applies to those aged 23 or over. Up until last year, it was 25, but it's now down to 23. And the lowest rate is for apprentices. The legislation also covers 4 types of work: salaried hours, time work, output work, and piecework. And each of them have different provisions for assessing whether or not the national minimum wage regulations are complied with. So it can get quite complicated. Employers who fail to pay the national minimum wage risk a knock on the door from HMRC and audits and inspections, and there can be quite a high level of fines if they are found in breach. The last thing I wanted to touch on is employment status, because quite a lot of small startup companies seem to prefer to take on independent contractors or self-employed people to minimize their costs. Because if they can do that, they don't have to deduct income tax and national insurance contributions, they don't have to pay holiday or sick pay, and the individuals don't accrue the rights to be unfairly dismissed. However, I sound a note of caution here, because notwithstanding what a contract may say between the end user and the independent contractor, or what the parties intend at the outset, if the individual is in fact operating to all intents and purposes as an employee under the control of the employer to their specification and with their equipment, and they can't take on work for any other individual, then they may well find, if it ended up in an employment tribunal, if, for instance, the end user decided they didn't want them to carry on working with them anymore, so they dismiss them and end the contract, the individual tries to say they are in fact an employee, And if the tribunal agrees with them, they will accrue employment rights. So you have to be quite careful if you are taking on self-employed people as to the terms and the flexibility around that. And there are also new rules brought in by HMRC this year to private companies with regard to self-employed contractors. They are quite complicated. They're outside the scope of this discussion, but I would just say companies need to be very careful if they are looking to take on contractors as opposed to employees. That's a quick canter through some key tenets of Welsh and English employment law. Thank you very much for listening. I'm happy to answer any questions at the end. As Alvaro said, I'm a partner in the London office of Royce Whitney King, and we deal with all aspects of employment law. So if there is anything that's thrown up some interest or sparks any questions, very happy to take questions at the end, or alternatively, I think the Chamber of Commerce has got my details, so happy to take inquiries individually as well. Thank you very much.
Thank you very much, Gemma. Victoria, over to you, please.
Thank you very much. I hope you can hear me all properly. I hope the sound is not too loud. First of all, apologies. I think they are lifting and drilling all outside my office, so you might hear some noises, background noises in the outside. Well, my chat, I think the best way to start is to explain what is a notary. I'm sure that there are a lot of listeners up there that they are also notaries, apart from solicitors, and they do exactly the same work that I do, but there are also a lot of the clients that they might be listening and they not really understand what is a notary, what we can help you as a solicitor or your client for being a notary, and also how can we be the bridge between the English jurisdiction and the foreign jurisdiction. What is a notary? Well, my first thing is what the Romans have ever done for us, which is creating the profession of a notary public. In the Roman times, they have private transactions, as we do have now, and they had a scribe, a transcriber, taking notes of that particular transaction, pretty much what we do now in our days. So we have a client coming to our office and we basically take note of exactly what is happening in our office, and that transaction is private. The way to make it, private. The way to make it public is to take note and prepare a notarial certificate of exactly what happened in this meeting. And that is what the Romans did, and that's how we still do it today. When they created the shorthand, then is when the proper term of notary was invented, as opposed to, because we're taking notes and we are notaries. How the profession of notary came into England? Well, the Roman Empire brought it in, and of course with the Reformation, with Henry VIII, he took upon himself from the papal legatees to appoint notary public. That's why in some of our notarial certificates, you see that we are appointed by royal authority. That's thanks to Henry VIII. Then obviously that will transfer to the church, and we are regulated by the Archbishop of Canterbury. We are under the church still, and when we qualified, we are provided with something called a faculty, which is what allows us to practice as a notary. And our faculty describes what a notary does, which is an officer of the law appointed by the Court of Faculties, whose public office and duty is to draw, attest, and certify documents from all over the world, including conveyancing, wills, testamentary disposition, and more. I'm not going to listen to all the read all the description of what we are. There is not something that we cannot do. We can notarize all type of documents. How can we help you with your clients or you as a solicitor is to, as I say, build the bridge between the English notary and the foreign jurisdiction with the Spanish notaries. How can we help you on an everyday basis? We have all type of documents, as all the other colleagues spoke, Gemma, Stephen, and Julia. We're talking about conveyancing, private documents, all sort of wills and testamentary dispositions. Conveyancing, for example, we try not to do in England, as we haven't got the link like a solicitor will have in England with the land registry. We usually recommend the client to choose a professional in the country, Spain, France, Italy, or wherever in the world, that knows his profession, is a trustee person, and we prepare or attest a power of attorney. A power of attorney is a very important instrument because obviously that person can use that document elsewhere in the world, like if it were them. So it's a very dangerous instrument. That's why the notary will explain all of that to the client. We prepare, in the case of, for example, my specialty is Spain, we draw powers of attorney for Spain because we know exactly what the Spanish authorities will require within the text of the power of attorney. It's a completely different document as you will encounter in England. It has a specific format that you have to comply with. The notaries or the land registry or the commercial registry will look for specific things within the power of attorney, and we know what those specific things are. That's when the solicitors or clients will come to us. Sometimes the documents are prepared by the lawyers in that foreign jurisdiction or by lawyers in the UK that they know how the Spanish jurisdiction works, and we can attest the signature on those documents, checking obviously that everything is correct and accurate. One of the main things, the difference between majority of documents that the civil law jurisdiction will use and the English jurisdiction is that in England, usually all type of documents mostly would be private documents, which is a transaction between the parties, whether in Europe will be public documents, which are those that the notary will prepare and the third parties will place the reliance onto them. Basically, what the notary did, the notarial certificate will produce within that public document. The main three elements that any power of attorney and any other public document will have will be identifying the parties, which is the identity. We must always, at any time, when the client comes to us, very similar to what the solicitors will do, which identify the person appearing before us. The person appearing before us, obviously by way of any identification, passport, driver license. And the second is the capacity of that person appearing before us. We have to make sure that that person has got legal capacity, knows what they are doing. Extremely important when you are executing wills, of course, but any other document, but especially wills. And the third one for company law will be the authority of the person appearing. That director has got the capacity to execute that document. So that's the three elements that any document that we notarize will obviously make sure that those three elements appear on that document. As I say, powers of attorney is probably the most used document instrument for foreign jurisdictions. Wills will be something that we will always be very cautious about. As a professional that deals with Spain, we can prepare Spanish wills. We know the regulations and we know what is expected. An English will obviously has to have a particular formality, which is that has to be executed before two witnesses. For example, for Spain, that is not a requirement. It has to be executed before a notary. If I execute a will in England and Wales, I will have to comply with the regulation of England and Wales. So I will always make sure that the two witnesses are present, different from me, which will be the figure of a notary, and that will be required for Spain. Wills for Spain must always be registered at the will registry in Madrid, something that obviously we don't have in the UK. What other type of documents can we execute? Well, company documents are extremely important, especially now with Brexit. A lot of companies decided to open branches in for example, Spain. We know what regulation or what is expected, what documents they would require to do so. We can help them with that transaction. We can notarize minutes of the board of directors. We can notarize, obviously, the incorporation documents like certificate of incorporation, memorandum and articles. Obviously, articles, memorandum is only the subscriber, but some jurisdictions still insist that they will request to have the memorandum attached with the articles. The company appointments, obviously to show who the directors of that company are. Shareholders, so the company's house now does not provide that, but the personal with significant control. When any resolution has to be registered, for example, a company's house can be submitted directly. That is not what it happens in Spain. Usually that resolution will have to, as we call it, be raised to a public instrument. What is that? Well, it's very similar to a power of attorney in public form. So basically we have to incorporate the decision that those directors have taken privately, internally within the company, will have to be incorporated in a public deed, and that public deed will go to the company's registry in Spain. We can help your client with that. We can explain what has to be within the document in order that that will work at the company's registry in Spain. Other type of documents that we also notarize, for example, are adoptions. We do, some notaries are specializing in shipping. We do as well as notaries, for example, in any couple that decide to marry abroad, we notarize documents to help them to achieve that. Parental consent, traveling is something that happens very often, especially in the summer, not now with the pandemic, but it still does. I still have customers coming in that one child is traveling with only one parents, and they need an authorization to travel. An authorization to obtain passports is only one of the parent is the one that is attending, for example, the embassy or the police station in a particular jurisdiction. So the list goes on. We can attest lots and lots of documents. The main thing is that we have got the experience to guide them through what, because we do this on a daily basis, we can guide them of exactly what those jurisdictions require, what documents might work or might not, and what department or what organization might have to contact, and also what kind of documents they might request in England to be able to be used in that foreign jurisdictions. I think I probably cover or pass my time. So I'm going to pass it to Alvaro. If there's any questions, if you want to just ask me any documentation that you might not be sure of what is needed or what is required or how to use that documentation abroad.
Thank you very much, Victoria. So we have one question. I think this question is for Stephen. Is the process of setting up a subsidiary or branch of an EU company in the UK different from the procedural steps for incorporating a UK company? And where can I find more information?
In terms of a branch in the UK, you only have to register the branch in the UK if it's got a physical presence here in the UK. So if it's going to trade from a premises. On the link that I provided you at the end of my talk, I provided you a link to Companies House website, which deals with overseas branches. So if you go through to that, that will give you more details. Is that helpful?
Thank you very much. I don't know if we have time for another question, but if there are any other questions that you would like to raise now, or if not, you will be able to email directly the speakers, who will be very happy to deal with any questions you may have. Well, that's all for me. Thank you all very much. Thank you, Victoria. Thank you, Gemma, Julia, and Stephen. It's been great to know the differences between, well, here in England, how different areas of law work that are totally different to, for example, in Spain. And well, I hope for the audience this has been useful. And well, that's all from me. And over to you, Hannah. Thank you very much for helping us hosting this event. We're very grateful. Thank you.
Fantastic. No, thank you, Alvaro. Thank you, everyone, for this talk. It's been so really useful. A lot of really great information there. I just wanted to add to what Alvaro just said. So after this session, I will be sharing the email addresses of the speakers. So if you kind of, after this, you think about any other questions you have, or if you'd like to find out more about their services and their firms, please do don't hesitate to get in touch with them. This webinar is also going to be recorded, and we're going to be serving on our YouTube channel. So if you think it could be really useful to someone that you know, please do share this webinar with them so they can watch it. That would be great. And yeah, thank you everyone for joining us. Thank you, Alvaro and the BSLA. We're really pleased to have, as I said, this is the third time we've held this session. It's always been going really well. So we're really pleased to be holding it again. Looking forward to the one next year too. But yeah, thank you everyone once again for your time and knowledge sharing. We really appreciate it, and hope everyone has a lovely afternoon. Thank you.
Thanks. Bye-bye.
Bye-bye.